Welcome back to the Conduct Detrimental Podcast. This is Dan Worley, one of your co-hosts. I'm joined, as always, by the other co-host, Dan Wallach. Dan, what's happening today?
Well, first of all, happy New Year's Eve, Dan, and happy New Year's Eve to our guest. We're definitely packing in an all-star lineup in these last couple of days of the year. Yesterday 2 days ago we had Warren Zola. Today we're going to have Paul Anderson taking us through the minefield of NFL and NHL and all the sports, concussion litigation. So, this is really going to be a good episode. More for me to learn because in the field of sports law, we're able to kind of like drill in on issues pretty quickly or pretty easily with a little bit of research. But I have to tell you that the world of sports concussion law is just so vast. That I think today's podcast is going to be a tutorial and a great teaching experience, and we're lucky to have one of the nation's leading experts on sports concussion law, Paul Anderson. Welcome to the podcast, Paul.
Welcome. Thank you, guys. I greatly appreciate you inviting me to come on. And first off, I got to tell you how phenomenal of a job you guys are doing in this podcast. Both of you guys are real pioneers in this area, and it's a great service to everyone out there to stay abreast of the sports law issues. I know I listen to these podcasts as soon as a new episode comes out, as I am running or working out at the gym. So I greatly appreciate it.
Thanks, Paul. We didn't have to pay him to say that even, so that's good to start. And Paul's an interesting case. He's really an inspiration, I think, for a lot of people out there. This isn't a video feed, but if you can see Paul right now, Paul's a young guy. I mean, I don't want to guess your age, but you're probably hovering around the 30-year mark, and just the amount that you've accomplished coming from, I think starting in law school and up to the point where you are now is pretty phenomenal. And I just because I have a website and I get law students frequently calling me saying, how can I break into the sports law industry? I get that a lot. So I talk with them, and I frequently use Paul as an example of someone who really utilized everything out there for himself, started a website, got his self-recognition, showed his expertise, and now he's practicing in the field and he's extremely successful doing so. So Paul, I think I'd love to hear from you. I mentioned the website's NFLconcussionlitigation.com. I'd love to hear from you. Why did you start that site? What's it become for you, and how did that open some doors?
Well, thanks for the kind words. I did just hit the big 3-0 in November, so I'm looking forward to the 30s.
Happy birthday! They're not too bad.
Thank you. It was a great experience. As you noted, it's very tough to break into the sports law arena. As a law student, I was like a lot of my colleagues at the time. It was a very tough economic market and job market. So my last year of law school, despite having good grades, I hadn't landed that ideal job yet. And so I had to figure out a way to try to distinguish myself from the rest of my peers. And I noticed that this legal blogging was becoming a pretty hot topic. And as I was researching for a law review article that I was going to write, I came across a report on the first lawsuit filed against the NFL back in July of 2011. So I started researching, and I was like, wow, this is pretty phenomenal. You have former NFL players making these allegations against the NFL of fraudulent misconduct over brain injuries. And it kind of brought together three areas that I really enjoyed: class actions, torts, and sports law. So from there, I figured, hey, why don't I start researching this issue? And I learned how serious brain injuries and concussions really are, and how they are affecting these former giants of the football era. And so I started writing my law review article, and I decided, hey, how can I, put my name out there and start a website? So I started the NFL Concussion Litigation website in January of 2012, and it kind of turned into the quote-unquote go-to website for the coverage of the NFL concussion litigation.
Paul, do you track all of the different lawsuits? I mean, that must be a monumental undertaking. I mean, NFLlitigation.com. I mean, we know that there are, at least 50 opt-out cases, but there are probably in excess of 100 separate lawsuits that have been filed. Do you track each one of those? Is there current information on your website, as to the status of the cases?
Well, to a certain extent, I do. Whenever I was really focused on the website and writing on a daily basis. I did that at the outset. But my role kind of transformed from commentator to litigator after I got out of law school. So I still stay abreast of the various lawsuits that are being filed, and I try to post as frequently as possible. But now a lot more of my focus is on actual litigation. We represent about 24 guys in opt-out litigation against the Kansas City Chiefs and the Arizona Cardinals, as well as we just wrapped up a case against the NCAA involving Derek Shealy.
Yeah, can you tell us a little bit more about that Derek Shealy case? I know that was a pretty huge settlement, and I know you guys did a great job, and you don't see the NCAA dishing money out that regularly, so you can tell us a little bit more about that case?
Yeah, Derek Shealy was a tremendously tragic case. And in fact, we filed this case basically as soon as I got out of law school. And it involved death of a 22-year-old fullback who played at a small college in Western Maryland called Frostburg State University. Derek Shealy was the captain of the team, and they were in training camp for the last season of his collegiate career. And during a 4-day period, his forehead was bleeding. He had a large bruise on his forehead as well. And finally, on the last day, he told his coaches, I can't go on any longer. And his coaches allegedly said, "Stop being a PUSSY, Derek, get back out there." Derek obeyed his coaches and subsequently took another hit and collapsed and never regained consciousness and died 6 days later from second impact syndrome. So we sued the NCAA as the governor of sports, to the coaches and the athletic trainer and the helmet manufacturer and helmet supplier. And we litigated that case in Montgomery County in Maryland, which is a suburb of D.C., over a 3-year period, and finally settled it basically a week before trial, with all defendants chipping in and contributing $1.2 million.
Wow. It's pretty incredible story, and obviously all of this essentially is a very, very sad story underneath it, but you hope that the money that comes from this, and we're gonna talk about some huge numbers in a minute here with the NFL concussion litigation, really helps the people involved and the people that are hurt. But let's move on to the NFL concussion litigation, which is the title of your website, so you must know one or two things about it, I would imagine. But obviously, it was recently in the news. The settlement for the big case, at least, was finalized and will not be heard by the U.S. Supreme Court. Can you really just kind of give us a background of what that lawsuit alleges? I mean, I know when I talk about the lawsuit with people, the frequent response that I get is, well, didn't the players know that you could get hurt when you play football, and shouldn't there be some sort of assumption of risk going forward? Can you combat that argument and really explain what the lawsuit was about?
Yeah, I'll start with kind of the outset of the basis for which this lawsuit was brought. We consider it basically the granddaddy of concussion litigation. It kind of paved the way for the rest of this litigation that you see going on around the country. So really, the basis of the lawsuit is that the NFL knew or should have known about the long-term risk of repetitive brain trauma that occurs in football, and the later life cognitive decline and issues related to brain injuries that arise whenever a player leaves the game of football. And so medical science, at least from our standpoint and our experts' standpoint, the scientific community has known about football-related dementia since the 1920s, and it really began with the boxers. Dementia pugilistica was the name that was first identified and coined by Harrison Martland. Basically, it's a form of now the term that you hear, CTE, chronic traumatic encephalopathy. And back in the 1920s, boxers were experiencing this, and then even the football industry started noting that football players should not be returned to play after suffering concussions. And then there was kind of a period for about 70 years, effectively, where there was in the literature there wasn't much of a link identified between football, brain trauma, and CTE. And it wasn't until Dr. Amalu, I don't know if you guys have seen the movie Concussion, which Will Smith plays Dr. Malu, really put this issue on the map. And Dr. Malu had the opportunity, by happenstance, to examine the brain of Mike Webster. And Mike Webster, he identified having signs in his brain similar to what they were noting in boxers in the 1920s. And he decided to term this also chronic traumatic encephalopathy, CTE. And then thereafter, multiple diagnoses were being made of other players posthumously, because you can only examine a brain after an individual has died to determine whether they truly have CTE. And so Dr. Malu brought this to the NFL's attention, thinking that the NFL would accept this with open arms. But on the contrary, the NFL said, no, there's no way that there's any link between repetitive brain trauma and CTE. So what the NFL did is they went on a mission to all but deny and dispute the link between repetitive brain trauma and CTE. So they appointed Dr. Elliot Pellman, who was a rheumatologist, to lead the Mild Traumatic Brain Injury Committee in 1994.
The mild traumatic brain injury. I love the title. What an unbelievably insensitive euphemism.
Exactly. I mean, it really throws it off. And to add to that, you have a rheumatologist who's leading this brain injury committee. A person who deals with knees and joints, instead of going out and getting a famed neurosurgeon or a neurologist or neuropathologist, they get a guy that deals with knees and joints, who was also allegedly the Commissioner Tagliabue's personal physician. So nevertheless, this committee spent the next 15 years publishing studies in scientific journals, flat out denying the link between repetitive brain trauma and CTE, stating that concussions in football are not serious injuries. There's no evidence that a player will suffer these long-term injuries. So thereafter, after 15 years, the scientific community engaged in this debate. On the one hand, people saying, no, it's absolutely clear that there's a link. On the other hand, you had the NFL who's denying it. Congress got involved in 2009, and they ordered a congressional committee on football and brain injuries, asking why so many retired players were dying at such young ages from suicide and other issues. And so in 2009, Congresswoman Linda Sanchez scolded Roger Goodell and even analogized the NFL's conduct to big tobacco. And I think that was one of the major, turning points or major points in the history of concussion litigation, is you had the plaintiff's bar taking note that Congress is, comparing the NFL's conduct to big tobacco. And mind you, this is around the same time that litigation had just wrapped up against big tobacco, in which billions of dollars of settlements occurred. And so thereafter, I think the plaintiff's bar began to study this issue and talk to players and retired players, and they found out that retired players had no clue that football can cause brain injuries. And as you noted, Dan, there's this idea that people will say, well, of course, what do you expect? You're huge 300-pound men banging your head over and over again. Of course you're going to have issues. Right, but whenever you have the NFL and your employer telling you that, no, you're not going to have any long-term issues, I think you accept what your employer says at face value. And yeah, you think you're going to have knees and back issues, hip issues, these orthopedic issues, but nobody really realized that the constant repetitive subconcussive blows that you get could turn into this full-blown dementia later on, or also CTE later on after your life, and cause some of these horrific acts of suicide that some players have suffered. And so thereafter, in 2011, the first lawsuit was filed out in California against the NFL, making these allegations that the NFL acted like big tobacco and misrepresented and concealed the link between repetitive brain trauma and CTE. And so it then spiraled into this massive concussion litigation where you had over 4,500 players filing lawsuits all throughout the country. And MDL was formed in the Eastern District of Pennsylvania in front of Judge Brody, and then the litigation proceeded from there.
Yeah, but Paul, despite the comparison of big tobacco, and we're talking about 4,500, 5,000 players, why did the class action settle for what is just a drop in the bucket for the National Football League? When you look at their annual revenues, which are $10 billion, if not more, per year, close to 5,000 players are going to share in a settlement pool of less than $1 billion. I think Judge Brody found that was not enough, and the parties went back to the bargaining table and came up with a modified class action settlement. Why did they get off so inexpensively relative to the possible liability and undoubtedly the vast damage across the spectrum?
Yeah, I certainly think that's a fair criticism, and our legal team was not part of the negotiations. We were not. We never even made a motion to try to be appointed to the steering committee. It was a group of about 12 law firms on the plaintiff side that led the negotiations and the subsequent settlement with the NFL, and just kind of to take a step back and talk about the formation of the negotiations and the settlement. I think what forced these parties to the table initially was the NFL filed a motion to dismiss, asserting that all of these lawsuits are preempted by federal labor law. Basically, that all these cases must go to arbitration and they don't belong in court, and they're not going to have a chance to have a jury award, billions and billions of dollars in damages, let alone even discovery that could, show the NFL's or prove the NFL's fraudulent conduct. So that was teed up in front of the court. You had on both sides some of the best lawyers in the country. For the NFL, you had Paul Clement, and then you had David Fredericks for the plaintiffs. They argued this case in front of Judge Brody, and Judge Brody took it under advisement, and she ordered the parties to go to mediation. She reportedly told the parties that you're not going to like the way I'm going to rule. I'm going to, to some extent, I'm going to gut all these claims. Some of the claims may stay alive, so that was a threat to the NFL of the potential risk of discovery. So I think the parties came together and said, hey, if we're not going to be happy with Judge Brody's ruling, why don't we see if we can mediate this and get this resolved? And that's what came out to this initially capped settlement of around $765 million that would cover all former players, not just the 5,000 that filed suit, but all former players, which is approximately 18,000 retired players are part of this class action settlement. And Judge Brody looked at the number, and she was concerned that despite the somewhat large payouts for certain claimants, there was not going to be enough money to go around for all. So that's where the parties went back to the table and negotiated an uncapped settlement, in which the amount is not going to be a cap on the amount, and every claim that meets these qualifications will be paid out. But that's kind of the rub of the settlement is, the settlement may be uncapped, but at the same time, only a small percentage of those 18,000, approximately 20% or less of those 18,000 are ever going to receive compensation. And that's really where the big issue and where the appeals came out is the settlement does not provide compensation to the overwhelming majority of class members. And despite them losing their rights to sue or proceed, in exchange, they're really effectively getting nothing because CTE was removed from the settlement altogether.
Yeah, so can you just talk through for the audience of how that's actually paid out and what the players, is this correct that the former players would need a diagnosis of dementia or Alzheimer's or something that would be linked to a head injury in order to recover any money whatsoever?
Yes, so the settlement only pays for Parkinson's, Alzheimer's, dementia, and a certain category of CTE. Individuals who died with CTE during a specific time frame. And anybody who dies with CTE after April 22nd, 2015 will never receive a dime. And according to the NFL's own actuarial data, it indicates that the overwhelming majority, and this is a quote from class council and the NFL's actuarial data, the overwhelming majority of class members will not be compensated because they do not qualify for a compensable disorder. And I think and then the other significant part, just to give you an example of this CTE cutoff date, is someone who's died after April 22nd, 2015, Ken Stabler. He died after that date. He's subsequently diagnosed with CTE, and despite being diagnosed with CTE, his family will receive nothing under the settlement. And that was really the core issue at stake on appeal of the Third Circuit, was this entire settlement, or this entire litigation was based on CTE, this quote-unquote industrial disease, and it was all but removed through negotiations and the settlement. So anybody going forward who dies and has this quote-unquote industrial disease from football won't receive any compensation for CTE.
I mean, could this change at some point if, medical science, or there's some breakthrough in the research that will allow CTE to be diagnosed in the living? I know there have been a lot of recent groundbreaking, research on how that might be possible. If you could detect CTE in a living person, would that individual be able to qualify as a claimant under the settlement? Or would the settlement, could you change the settlement to open it up to include CTE diagnoses in the living? How do you address this if 1 year, 2 years, 5 years down the road, you can begin to diagnose it in the living?
You're exactly right. And that's one of the major issues with this settlement and we weren't part of the objection process either. Our guys just opted out. So we wanted to preserve our guys' claims because none of them would be compensated under the settlement. And so we're going to proceed with their claims going forward. But to answer your question, we believe, and the objectors asserted, that this settlement freezes science in place. And why we say that is because the settlement specifically provides that despite these innovations and the ability to soon, if not currently, diagnose CTE in the living, the settlement specifically provides that it will not compensate an individual who, let's just say as an example in the future or now, an individual who has an in vivo diagnosis of CTE. They won't qualify, and the settlement won't be modified for that determination, if that's ever possible, which we believe it will happen soon. So if a player in the next 10 years is diagnosed in vivo with CTE, that still will not provide them for compensation under the settlement. The only way that they can receive compensation is if they have one of these qualifying diagnoses. So if they have CTE and dementia, some type of neurocognitive deficits, neurocognitive impairment, then they could get compensation. But effectively, CTE has been taken off the table altogether, despite what other innovations may occur in the future.
I mean, that just sounds, outrageous, given how quickly the science and our knowledge about CE is just emerging, in like lightning fast fashion. I mean, 2 years ago, we weren't talking about CTE, and now it's on this like bullet towards, becoming this fully realized type of diagnosis. And it just seems like the settlement is archaic, or will seem archaic in 5 years. I mean, how did the courts approve this, and how did the Class Action Council not include a carve-out in the settlement agreement for CTE diagnoses in the living? Wouldn't that would not have created a rupture to the NFL's exposure?
Yeah, I'd agree. I think what Class Council argued is a couple things. Is one, it can still compensate somebody with CTE if they have dementia. So it's kind of
but it reads CTE out of existence. Because really CTE doesn't matter.
I agree, and I think that that's what the objectors noted, is really that's kind of a red herring on the part of Class Council. The NFL said we're not going to pay for anybody who has CTE just because, the classic symptoms of CTE is mood and behavioral issues, and the general population has mood and behavioral issues. So why do we want to open up the pocketbooks for anybody who has these mood and behavioral issues? So that's what class counsel said is, look, we tried to negotiate this. We tried to get the NFL to pay for CTE, but it was just a matter of line drawing, and the NFL was only willing to go so far. I don't know. We weren't part of the negotiations, so I just taking class counsel at their word. I assume that they negotiated the best deal that they could get, and the NFL may have not been willing to budge. But I think we can all agree at the end of the day that this entire exclusion of CTE is entirely unfair, and that's why our guys opted out of the settlement.
So talk about that the opt-out cases moving forward. I know that you, as you mentioned, you represent a number of them. I mean, you're at least involved with a number of them. And, it seems like that's going to be the new thing moving forward, or like the leftovers. How is that shaping up procedurally moving forward?
Right. So initially there was around 200 players that opted out, former players that opted out. I think the number has now been whittled down to approximately 100. And, we've been, all of the opt-out litigation has been stayed pending the resolution of the entire class action settlement. And that pretty much has come to an end now that the Supreme Court has denied cert. So that you're right. That's going to be the next phase of litigation. I think the NFL concussion litigation is really far from over, because you have several opt-out cases that are going to proceed either on a collective basis or on an individual basis. And we're waiting for Judge Brody's order, in which she sets a case management order together as to how these cases are going to proceed. I think first off, the NFL is going to say that all these cases, just like prior to settlement negotiations, are barred by the collective bargaining agreement, are preempted. So therefore, none of these cases belong in court. Instead, they should go to arbitration. So we anticipate probably in the spring of 2017, these issues will be briefed up for the court, and Judge Brody will rule on whether our cases, as an example, should go back to state court in Missouri, where we initially filed these cases, or if they belong in federal court, which we do not believe they do. And if she grants our motion to remand and sends our cases back to state court, then we're off to the races into discovery and subsequently trial.
All right. How closely have you been following the NFL's litigation with their insurance carriers? The NFL gets this, terrific deal where they're paying, basically, pennies on the dollar to settle the granddaddy case. And yet they're trying to get their insurance companies, their insurance carriers like Altera and Discover to foot the bill for all of their concussion payments. Well, these insurers have just gotten the green light to obtain discovery from the National Football League, documents, depositions. Will you be involved at all in that process or in any way hoping to get documents? How important is that case for the opt-out plaintiffs?
Well, it certainly sets up an interesting dynamic where you have the insurers effectively seeking similar discovery that the plaintiffs in the opt-out litigation will want. I mean, the insurers have already noted in their briefing that they want to find out what the NFL knew and when they knew it, and their goal is to find some type of exclusion, and that exclusion would be if the NFL essentially committed fraud on the players. So certainly we are interested in what they discover. It looks like, based on the case management order that came out in New York, that the insurers are going to start propounding discovery on February 1 of 2017, and then depositions are going to begin shortly thereafter. I think based on efficiency and judicial economy, you would certainly think that the plaintiffs in the opt-out cases, since it's similar discovery, should be entitled to see what discovery is being propounded and what the merits of these claims are.
Yeah, but do you see the NFL moving to settle this case much more quickly now? The NFL has lost several rounds of trying to stay discovery in the insurance dispute. Most recently, 2 days ago, New York's appellate division denied an interim request for a stay pending appeal. So now, for all intents and purposes, it's full steam ahead for the insurers. Will the NFL move quickly to settle this case to keep that kind of discovery out of the hands of the insurers and consequently out of the hands of the opt-out plaintiffs?
Well, who knows? But I think we all know that the NFL certainly has the money to foot their own bill if they want, and it just comes down to exposure. Do they want this information? Are they concerned that the discovery process will be explosive, like the majority of people believe? And if the NFL weighs that risk and just determines, hey, let's just bite the bullet and fork this bill ourselves to pay for the settlement, the NFL concussion settlement, and to resolve this coverage action. Sure, I think they will take that step. Of course, that still now they have to turn their focus to the opt-out litigation, where again we're going to be focusing on the same discovery. What the NFL knew and when they knew it, and what they did to inform or not inform their players. So one way or the other, we're going to get to the bottom of the NFL's and the Kansas City Chiefs and the other teams' misconduct.
Interesting. So is it the NFL's position that the entire settlement is covered by insurance? Is that what they're arguing in that case?
Yeah, that's really the core contention. The insurers are saying that we don't have a duty to indemnify based on exclusion that the NFL committed fraud on the players, and the NFL is saying no, you do have a duty, and you need to fork over the settlement amount to cover the main underlying class action litigation.
Right, it's really interesting. It's been a pretty underreported piece of this. When people say, "Oh, well, it's just $1 billion to the NFL," well, in reality, the NFL's not going to pay any of that out of its own pocket, potentially, depending on how that all goes. So,
right, and the insurers, they've already paid a tremendous amount in attorney's fees alone for the duty to defend that the NFL defended the class action settlement. So, you can only imagine how much the Paul Weiss law firms are billing on an hourly basis, over $1,000 an hour. And this litigation has been proceeding for 3.5 years, not longer. I'm sure those legal fees are pretty huge.
Absolutely. So, one thing that Dan and I were talking about before that we found really interesting are, the rule changes that have taken place since this has become a mainstream issue. And we see concussion protocol in the NFL, college sports, high school sports. Do you see these rules? Are they working? Is there going to be more changes coming? Do we see, there's, I can't remember the case this year, but there was a clear concussion in the NFL, and the spotters didn't see it, and it's just like, oh my gosh, I can't believe you guys are still getting this stuff wrong. What's in the future as far as rule changes, and do you think that they're still considering changing some of the ways that the game is played?
Yeah, I'll begin with just an anecdote. Whenever I first started researching this in 2011, whenever I put new content on my website, I would always try to find various concussion articles. And at that time, I would find a concussion article once a month. And by the time the litigation was filed and it really exploded onto mainstream, on Google Alerts, you're seeing a gazillion concussion articles. So I think that's an indication of the awareness that the entire concussion litigation has brought to the public. And I think that has been a tremendous service to all athletes, to all parents, in getting educated about the serious risk of repetitive brain trauma and concussions. So despite putting all the legal issues aside, I think the concussion litigation has really done a tremendous service to the public and to the players' health going forward. And of course, with the newfound awareness, it has brought these rule changes. And I think to the overwhelming extent, the rule changes have been positive. We can start, for example, at the NFL level. Certainly there are still several hiccups I think the example you were talking about was Casey Keenum, the Rams quarterback.
That's it.
Who was blatantly missed. But you look at the NFL where you have 14 doctors on each sideline, various eyes in the sky. I mean, every possible thing imaginable to identify concussions, and at times you still have missed concussions. But I think we should probably focus at a much more lower level, and that's at Pop Warner and middle school and high school and even college. The NFL players now are getting paid several $100,000s, and they're being well compensated, which is a good thing. They certainly deserve that. And they have a fairly solid and competent medical staff now that are cognizant of concussions. But you don't have that same level at the middle school, high school, or even Pop Warner level. A lot of these kids are being told to still engage in head-to-head contact, despite having concussion symptoms, and being told to go back in. And I think that's really where the NFL should focus on real rule changes. And maybe the real rule change, or maybe the real change that needs to occur is that tackle football, we need to consider whether kids should even be playing tackle football. We know that brain trauma is not a good thing. So why are we allowing these kids at 6 years old to put on a big, heavy plastic helmet with hardly any neck strength yet at all to engage in contact, head contact, and subsequently brain trauma? Maybe the NFL should start heavily promoting, instead of quote unquote safe football or heads up football, maybe they should start promoting flag football. And you look at the Tom Brady's of the world. He didn't start playing football until he was 14 years old, and obviously he's one of the best players of all time. So I think if the NFL wants to make sure that football can survive and also thrive, it's going to take more than just pushing the kickoff back or concussion protocols. I think it may come down to a time that we need to look outside the box and figure out a way to ensure that whenever these athletes subsequently make it to the NFL, that they don't already have CTE. And that the only way that I think we can do that is by eliminating brain trauma whenever these kids are at such a young adolescent age and their brains are still developing.
But Paul, this is laying a lot at the NFL's feet to basically have this channeling effect throughout all of youth and middle school football. Wouldn't this be a better opportunity for Congress to intercede and get more directly involved? Do you see that happening at any point? Because the NFL can only, the NFL can't keep its own house in order and has difficulty and just trying to promulgate safeguards and rules and then adhering to them. I mean, that's trouble enough. Is there something that Congress can do, or state lawmakers? And I'm not too hopeful that Congress will do anything. But do you see that day coming soon where there will be federal legislation in the area?
I think you're right. It seems like the only two ways in which real change is affected is through congressional action or litigation. And, oftentimes, just, as an example, in 2009, when Congress brought in the NFL and said, rule changes need to be made, you need to start protecting the players, and then subsequent litigation, I think it has had this promising effect. But yeah, I think on a grand stage, in the best of worlds, congressional action, forcing some type of legislation, and I don't know, what the resolution would be, but forcing some type of change. It has happened to a certain extent. Every state has passed a concussion law that mandates that any player that suffers a concussion must be removed from play and is not allowed to return to play until they're cleared by a physician. So that's an example of legislation that has progressed in a positive way. But at the same time, I don't think the NFL, you're right, they can hardly keep their house in order. But at the same time, I don't think the NFL should get a free pass. They are the proprietor of football. They obviously benefit from USA Football, from Pop Warner, from promoting football at the very basic level, the very beginning level, and being able to get mothers involved and providing them with some idea that football can be made safe. So I think really they do have a duty. The NFL does have a duty to make sure that if they want this game to survive, I mean, these kids are the lifeblood of football. They're the lifeblood of the NFL. If they want the NFL to survive and continue to be a money-making machine, it's the NFL's responsibility to do that in an honest and truthful way. And right now, frankly, I don't think they are being honest with mothers.
Well, they have the litigation risk hanging over their shoulders. So it's this inherent conflict that any positive measures that can be done are compromised by the possibility that can come back and create a litigation threat to them by virtue of conceding or acknowledging something. Is there some difficulty in having this kind of risk hang over the NFL, yet charging the NFL with the duty to impact change systemically?
I think that you're right, but that's often from my viewpoint, is a cop-out. That you see this often in industries and companies is they take this approach that, hey, well, if we get involved, we're going to subject ourselves to litigation. Well, actually, if you get involved and do the right thing and implement the right changes, you can prevent litigation, and that's your responsibility. So, I mean, in the perfect world, of course, I think they would do the right thing, tell the truth, and be honest, just like every other company. But everybody is so concerned about what the effect of their conduct is going to be that they engage in this risk mitigation to a T that subsequently leads to increased risk.
Well, these are post-remedial measures that shouldn't impact their vulnerability or increase their exposure in litigation. But I just think the NFL has been lagging behind the rest of society and lagging behind science. And when has the NFL or for that matter big business ever done anything voluntarily, or at least in anything more than a half-assed or half-measured sort of way?
I think you look at the NBA right now and you see Adam Silver being progressive on a number of issues, and you see the public response is all positive. They're in a much better place to a certain extent than the NFL, and I think that a number of lessons can be learned by that. I mean, Adam Silver is obviously a lawyer as well as a very seasoned and smart guy, and he's doing those kinds of things. So what's holding the NFL back here?
I agree. I mean, it was funny. My buddies and I were talking about Silver the other day about what a tremendous job he's done for the NBA, and you also look at Major League Baseball as well. Having guaranteed contracts, I think, really go a long way. But unfortunately, it looks like the NFL and the NFLPA are constantly fighting each other, and they can't provide for just the basic job protection and job security that so many athletes deserve, especially at the professional level, and let alone just the college aspect of the unfairness and inequities that are going on in sports. It's a question that we're going to be discussing and potentially litigating for the next foreseeable future.
Yeah, I think that's a good segue to cap our NFL talk and move on quickly to the NCAA side of things. The NCAA has settled its concussion litigation, the big one. It's all done. It's over with. But now there's a number of other lawsuits popping up. Paul, can you talk about those? I think there's been 40 to 50 filed in the last year.
Yeah, so the NCAA concussion litigation is pretty interesting in that it kind of followed a similar mold that the NFL did. There was a multi-district litigation in MDL that was formed in the Northern District of Illinois that consolidated these 40-plus individual lawsuits that were filed against the NCAA, conferences, and individual member schools. There was a class action settlement that was preliminarily approved that is going to, it's a medical monitoring settlement that's going to potentially provide medical monitoring for any former NCAA athlete, whether they were a swimmer, a bowler, any NCAA sanctioned sport. they are going to be entitled to what's called medical monitoring. And effectively what it will provide is that an athlete will if assuming the settlement is approved, finally approved, granted final approval, that is, then each NCAA athlete will receive some type of written questionnaire in the mail. They fill it out, and if it's determined that they are having some cognitive issues, then they'll come in for an examination by a neurologist, a neuropsychologist, and then they can be diagnosed with some type of issue if they're having any. And Dan, this is a going back to your point about the progress in science. The NCAA settlement actually provides, although it isn't going to provide for any compensation, it does provide for the innovation in science. So one part of the NCAA class action settlement is that whenever an in vivo diagnosis of CTE can occur, whenever it becomes readily available and approved by the FDA, an athlete potentially in the next 5 to 10 years under the NCAA's medical monitoring program, under the NCAA class action settlement, an athlete can be diagnosed with CTE and receive that diagnosis. And then, as part of the settlement only provides for medical monitoring and preserves an individual's right to file a personal injury claim directly against the NCAA or the member school or conference. So, effectively, what this has set up, the NCAA settlement has set up, is that an athlete in the future can get a diagnosis with CTE, and then file an individual personal injury action against the NCAA for compensation for the CTE that they're suffering from. So I think that may very well be the next major wave in concussion litigation is litigation against the NCAA and individual member schools.
Yeah, Paul, does the NCAA's medical monitoring settlement cut off the right to bring class action lawsuits? And
yes.
Yeah.
Okay. Yeah, it does. So what it does is it for certain, there's a carve out for certain class actions that can still be brought, and I think that's what Dan Worley was talking about the 46 cases. So what the judge did in the Northern District of Illinois, there's the large class action medical monitoring settlement, and then there's a subpart to that, which is single sport, single school class actions. That over the past year and a half or so, 46 lawsuits have been filed all around the country against the NCAA, individual conferences, and individual schools for what they have now termed the single sport, single school class action. And so that allows for a very small class action to be brought against, as it descriptively states, a single sport such as football against a single school, so representing a group of athletes, group of football players against a single school. And that is currently ongoing. There was just a case management order that was entered, and an appointed lead counsel, and then the next step is they're going to select basically test cases to go through the merits of discovery and see if they can even certify a class again based on a single sport in a single school. So that is currently also pending in the Northern District of Illinois, and on, I think, the end of January of 2017, the plaintiffs are supposed to select their test case to determine whether they can get these type of single sport, single school class actions certified.
Okay.
Interesting. So that's the what's coming your way soon in NCAA litigation. I know that there's concussion litigation in other sports as well, probably most notably the NHL. What's happening on that front?
Yeah, the NHL concussion litigation is very fascinating. Unfortunately, it's not getting as much media attention as the NFL did, but it's well beyond merits discovery. There's been some pretty eye-popping discovery that's been uncovered. You know, have some very inflammatory statements by the high-ranked officers of the NHL. And so what was just recently filed in December was the plaintiff's motion for class certification. And so they're well beyond any preliminary issues, and they're truly at the briefing for class certification to see if they can certify a class of all former NHL players that suffered repetitive brain trauma. So the allegations in the NHL concussion litigation are similar to the NFL in that the plaintiffs allege that the NHL knew or should have known about the long-term effects of repetitive brain trauma in hockey and the link to CTE, and instead of educating and putting in place rules to protect the players, the NHL profited on the violence through allowing and somewhat condoning fighting in hockey, and the violence that comes from the fighting aspect. So that case is proceeding. It's been proceeding for over 3 years now, and the plaintiffs have won several significant rulings. One ruling that they got that's very helpful for all professional sport litigation going forward was the preemption issue. Judge Nelson in the District of Minnesota denied the NHL's motion to dismiss based on preemption, finding that these claims are not barred by the CBA, the same argument that the NFL raised, stating that these are state law claims that can be interpreted without referring to or relying upon the CBA. And so effectively what she's allowing these cases to proceed. Like I said, players have been deposed, the executives have been deposed, and now they're at a stage where they're going to see if they can get this case certified. And of course, if a case is certified, that really changes the dynamics, because instead of 8, 15, 20 individual plaintiffs, you now have a class of several thousand. That really increases the pressure for the NHL. And the NHL is going to file their opposition sometime later on this spring, and I believe the hearing on that certification motion has been set for July 7th or July 11th, 2017. So that'll be something to keep our eyes on as well as we go through the rest of the winter and spring and into the summer.
Yet fighting continues unabated in the National Hockey League. Do you find it, bizarre that despite efforts to, reduce fighting, that it's still part of the culture of hockey? And given all we've learned about, the hockey player suicides, Derek Bugard and the unfortunate early deaths of other enforcers, do you think we're going to see the day soon when hockey is actually legislatively eliminated from the game?
I think that's a question that is certainly on everybody's mind. You have a lot of former players coming out now saying, we should do away with fighting. On the other hand, you have others that say, no, fighting is an essential part of the game. And I think that is an issue that actually is a labor issue that has to be resolved between the NHL and NHLPA, because you think about it, that is an entire position, the enforcer, an entire position within the market, the labor market, that is dedicated to fighting. And by eliminating the enforcer, you eliminate a certain part of the workforce. And how the owners and the NHLPA can come together and figure out a solution to that is something that probably needs to be made beyond just the litigation realm, but instead in the best interest of the sport, the best interest of the players that play it, and the future of the NHL and the kids that are playing the game at the Pee Wee level all the way up through college.
Yeah, I mean, shockingly, I hate for the NFL to look good by comparison, but the NHL has lagged behind the NFL in acknowledging reality, and they're still in a state of denial about the link between playing the game of hockey and developing these kinds of symptoms, post-career. The NFL, came to Jesus, during those congressional hearings in, it was March or April, when Jeffrey Miller, finally acknowledged a link. But to this day, the NHL still, is intransigent on that issue. What do you see any shifting in that position, or is it still, they're basically dug in because they're in litigation?
Yeah, you're exactly right. In fact, I never thought that the NHL concussion litigation was going to be as prominent or as successful as the NFL, because in the NFL you didn't have these explosive allegations of the NFL literally creating junk science. Against the NHL, you didn't have those allegations, and I thought the NHL historically had done a decent job in setting up protocols. But in the heart of litigation, what we find out is you have Gary Bettman voluntarily writing an article in response to a congressional letter where he flat out denied the link between repetitive brain trauma and CTE. So I think the plaintiff's case got a whole lot better whenever Bettman decided to write that missive in which he disputed and denied the link between repetitive brain trauma in hockey and CTE. And I'm sure the plaintiffs are having a heyday. In fact, they recently filed a motion with the court asking that they get to redepose Bettman because of this new evidence that these new publicly reported opinions that he's decided to lay out. And I'm still kind of in shock that the NHL counsel would allow him to write this, or would say this is a good idea. So, I think the dynamics of the case against the NHL has gotten much better since it was first filed.
Yeah, I mean, some of these emails that have come out in the motion for class certification are just outrageous. Recent emails. I mean, the NFL is accused of concealing, or concealing the risk from the players a long time ago. But the NHL is doing it even to this day. Emails from a couple of years ago, concealing diagnoses from the players. I think the discovery in the NHL case really serves as an interesting preview of what's to come with the NFL once the insurers get their hands on those documents.
Yeah, I absolutely agree, and it's the case still has a long time before trial, But every day it's getting better for the plaintiffs, it appears.
Yeah, definitely interesting to keep an eye on. I mean, has any of these cases that this would be the first big trial? I mean, at least big class action trial moving forward, assuming that it would get to that level. Is that right? Everything else is settled before got even close, right?
Right. I think our Sheely case was probably the case that got the closest to trial. We were walking up the courthouse steps effectively before trial started. But on this NHL, I mean, it's such a massive case. It's a rare MDL that actually goes to trial. But if the parties are able to get past all the substantive motion practice and it to go to trial, I think would be quite a development in the sports law arena.
Yeah, that'd be a fun one, even if it was the NHL, which, historically is kind of the running fourth in the major sports. But I think it would be explosive, and from what we've seen already, a just really interesting trial. I have, one more. We're running short on time, as we promised Paul that we'd be done, 20, 30 minutes ago. But just as far as the manufacturers go of equipment. What's their liability been? I know that they've been sued all over the place. Has that put companies out of business? Where do we stand with manufacturer liability?
Yeah, it's a fascinating side note on a couple fronts. And just as an example, in our Derek Sheely case, we sued the helmet manufacturer and supplier, Schutt Sports, and the supplier. Which is a small company out of Pennsylvania. And what our case, our theory of liability hinged upon was essentially misrepresenting the quality of a helmet. And I think that's what manufacturers find a large target on their back, is because they are overemphasizing the protective capabilities of a helmet. The majority of the public believes that a helmet can prevent concussions or reduce concussions, or is designed to prevent or reduce concussions. And I think the reason why the typical consumer believes that is because that's what the manufacturers have put in consumers' minds, is that a helmet, you put this big plastic thing on your helmet, you buy the best equipment, it's going to be able to prevent concussions. But that's absolutely false. And I think the manufacturers got way ahead of themselves in that idea and their marketing efforts back in the 2000s and 2010s. and they've done a tremendous disservice to the public. The sole purpose of a helmet, and it hasn't changed since its inception, is to prevent skull fractures. And it's done a pretty solid job at that. But it's not going to be able to reduce concussions because you think about your brain is inside a hard casing of your skull. No matter what you put around your head, you're not going to be able to keep that quote-unquote jello from racketing around inside your brain, inside your skull. So no matter what the progress that is made in the manufacturing and the design of helmets, I'm not sure the helmet is ever going to be able to reduce concussions or even prevent concussions. So I think manufacturers have an obligation, or they absolutely have an obligation to be honest and truthful with consumers, and that is another subset of the NFL concussion litigation is currently against Riddell. And that is another part of the NFL concussion litigation that is still proceeding. There hasn't been any settlement discussions in that regard. Is numerous players still have pending claims against Riddell. And Riddell is alleged to have acted somewhat in cohorts with the NFL in creating junk science about the abilities of a helmet. So we'll see whether the plaintiffs are going to be successful in proving their cases against Riddell and the Riddell's alleged failure to warn about the helmet's inability to protect against concussions.
Yeah, I have one last question for you, Paul, before we get to the real finisher, which is you can't let a podcast go without a Donald Trump question and what that might mean for subject X, Y, or Z. I mean, that's the du jour question of December. But with all the talk of settlements, with the NFL settlement being in place and the NCAA having reached a medical monitoring settlement, we're still seeing an avalanche of new case filings. The NCAA had 40 some odd suits, and now the UFC, I'm sorry, not the UFC, the World Wrestling Entertainment. I want to talk for a second about combat sports. Of all the sports that would pose the most likely incidence and recurrence of brain injuries, I think combat sports would probably be at the top of the list. Boxing, wrestling, MMA. What's going on that front with litigation, and where is there a next wave of litigation that you expect to see coming down the pike that where it will become one of the more important subjects? Because I don't think the UFC is too new. And but I think wrestling, boxing, and mixed martial arts present a whole category unto itself of potential concussion litigation.
You're right. As a plaintiff's lawyer who's litigated these cases, from my point of view, I wouldn't be able to take one of the combat sports cases unless it was some instance in which an athlete was clearly concussed and a doctor evaluated the athlete and returned to play, and then they subsequently suffered a traumatic brain injury such as second impact syndrome. I think those cases are very difficult on a failure to warn basis, just because the defense of assumption of risk and open and obvious is pretty apparent, in which the sole purpose in boxing and these combat sports is literally to give your opponent a concussion, to knock him out. But with that being said, there is a massive hole in the knowledge of these combatants, these athletes that are engaging in boxing and fighting. In fact, just as an anecdotal story, I was talking to an athlete the other day, and I said, "Do you know?" I asked him about CTE and whether he's ever even heard of it. And despite being involved in fighting for the last 5 to 10 years, he didn't even know what CTE was. And that really is truly alarming to me. That if you have this billion-dollar organization such as the UFC or these other organizers of sport, and they're not even taking the effort to educate their athletes about CTE and another quote unquote industrial disease that was known about since the 1920s in boxing, they're not even taking the measures to educate these athletes. I think that does open a potential door for liability. So who knows what clever lawyer may put together a group of former UFC fighters or other combatants to file a case that may very well happen. I think they're going to be subject to a pretty significant assumption of the risk defense. But I guess the question is going to have to be framed in a particular way, that what risk did they really assume? They may have assumed the knockout punch, but did they assume this later in life cognitive issues such as dementia or even CTE? And I think if the question is presented in a very narrow way and focused on CTE, there may be some merit to that litigation, and who knows, maybe we will see that next.
All right, Dan, you gotta ask your Trump question now.
All right, as we delicately and subtly move from Barack Obama to Donald Trump, we have many differences between the two presidents, the president-elect. I noticed that they have starkly different views of the concussion issue. Barack Obama stated a couple of years ago that he'd think twice about letting his child or children play football. But on the other hand, Donald Trump doesn't think that there's enough violence in the NFL, and has actually called the NFL soft, in reducing and trying to safeguard the players. How do you see Donald Trump's presidency potentially slowing down or detrimentally impacting any further positive developments in protecting athletes?
Yeah, I'm certainly concerned. I mean, those statements that he made while he was on the campaign trail were a tremendous disservice to the public, essentially poo-pooing the idea of protecting an athlete whenever they suffer a brain injury. That is alarming, and that's troubling. I guess the only thing is, obviously, I was not a Trump supporter, but one thing that I think we've all realized is whatever we think is going to happen, it may not happen. So hopefully it's just more rhetoric on Donald Trump's part. He did recently join with Jim Brown, I think that was his name, the former NFL player, and I know Trump and Brown. Let me make sure I have his name. Is it Jim Brown?
Yep. Greatest running back of all time.
Yeah, exactly. I apologize on my lack of historical knowledge. I know Jim Brown has been pretty outspoken about CTE and concussions, so my only hope is that Jim Brown is going to have Trump's ear in that regard, and Donald Trump will accept it as fact that repetitive brain trauma causes CTE, and maybe Trump will be the guy that is an actual advocate for these athletes. That can be our only hope. But as we've all learned, we know nothing whenever it comes to Trump.
Yeah, another case of the big mystery of what will happen during the Trump presidency. But hopefully this one taking action on this is far down his priority list, and he'll kind of keep out of it. But in any event, Paul, it's been amazing getting to talk to you, getting the total history of all of this. I know I've learned a ton. I'm assuming Dan has as well, and I'm
absolutely
sure that our listeners are extremely appreciative of you coming on. So we wish you a extremely happy and lucky 2017, and thanks again for coming on.
Well, guys, thanks again for the opportunity. It was a true pleasure. I love listening to your guys' podcast. You're doing a tremendous job, and I can only expect that it's just going to get better in 2017.
Appreciate that. We're definitely going to bring you back soon when specific things come up.
Yeah, and this is definitely a relief for me because I dreaded this episode because it was the hardest one to prepare for. So, got that out of the way in 2016, and I think it's fitting that you're the final guest of the 2016 calendar year, and you're one of the first people that I followed, on Twitter, and I view you as the seminal expert in the field of the law surrounding sports concussions. So I urge all of our listeners to follow Paul on Twitter at Paul D. Anderson, and to check out his path-breaking website, NFLlitigation.com. I wish you and your family a happy New Year, and thanks for joining us on the final episode of 2016, Paul.
Thank you guys again. Have a happy New Year.
Thanks, Paul.
Thanks.